Excellent. We're good to go. So thank you very much indeed for joining today. We've got Dave from our team here at ArcFlux talking and answering questions with regards to GDPR and privacy, both pre and post Brexit, what the impact is to organizations, and what you can expect. So this should be a great session. As always, please share your contact details in the chat just so that anybody can reach out afterwards if they choose to do so. Likewise, if you have any questions, please don't hesitate to put those in the chat as well, and I shall interrupt Dave at an opportune moment. But yeah, this is really your time to get those questions answered. So please make sure that you get to ask them before you drop from the session. With that, Dave, I'm going to hand over to you if that's okay.
Wonderful, thanks, Ollie. Yeah, hi and welcome everyone to my session today. So what I want to talk about really is, as the title suggests, championing business and what the changes to the privacy landscape, data protection landscape have really meant in 2020. So GDPR, Brexit, Privacy Shield, there's been headlines all over the place around these topics. So I really want to cover off, kind of from my perspective, what are the challenges that businesses are facing, and also just kind of clear the air around what is the impact of deal and a no deal Brexit when it comes to the UK digital economy. So just for context, really, my name's Dave Horton. I'm acting as the CISO and Data Protection Officer for ArcFlux. For those of you that are familiar with ArcFlux, obviously Oliver, runs that company, and we've been aligned for a very long period of time around what it means to have data subject information stored geographically where it makes the most sense, and also what the law says and dictates should make the most sense. So a lot of the discussions that I'll have today are really from conversations I've had with hundreds, if not thousands, of customers of data products that I have been involved with in the past. And really to kind of progress on with the agenda, as I discussed, I'm going to cover off firstly, the GDPR and Brexit. What is actually going on? Why is there so much kind of disruption, I should say, in the news right now around the negotiations and what that means for data protection. An interesting segue with the Privacy Shield framework, which is an agreement between the European Union and the US. So some interesting updates in the last few weeks on that particular process. I've put Q&A down at the end, but really if you do have any questions en route, feel free to drop it in the chat, or even unmute yourself if you wanted to ask a question. More than happy to field that. Now, the first thing that I'll do is kind of give you a bit of an insight as to what are the timelines, what have we seen as we go forwards. And this will be kind of familiar, but it's quite good to look back at some of these dates and really know what does it mean when it comes to changes for our business. So I'm going to try and be very much fact-based on this presentation. I think it's very easy to get to be kind of opinionated on the topic, if not partisan. But I'm going to try and stay as neutral as possible, a bit like Switzerland, and make sure that we're kind of covering it very pragmatically. So really to highlight the first thing, the UK voted to exit the EU on the 23rd of June 2016, and this was really a catalyst in motion that meant that we had to look at some of the relationships we had with Europe around all facets of business. So whether that was the digital economy and data transfer cross-border, whether that means trade through ports, etc., immigration, all of these things had to be re-looked at to see, well, how can we easily extract the UK from a lot of these intertwined agreements that have actually been established and built up over decades. And now fast forward a couple of months, and within March it was formally announced using Article 50 that it would be the decision of the UK to actually leave the EU. And now when we start to look at in parallel, this isn't related, by the way, the GDPR comes into force, and this was a unifying regulation which helped a lot of the member states of the European Union to have one single law that they could write and adopt into their local laws that was of the same language. Prior to this, each member state had their own privacy rules and laws, and it was very difficult for businesses within the EU to actually speak the same language when it came to that legal transfer of data. Bearing in mind that the previous Data Protection Act was 1998, at that point in time, the internet was a very different beast as it was in 2018. So it was very much the case that it needed a refresh. Now, as we go forwards, we'll start to see that we officially left this year in the early in the year around leaving the EU directly, and we've been in this transition period ever since. And in an ideal world, this transition period would allow companies to modify their contracts, adapt to new processes. But this didn't really happen because no new agreement from the government and the EU was really clarified, and specifically on the clarification for data protection. It was not really something that had been factored in, that it would take such a long time to negotiate. And now we're heading towards the 31st of December. And this really means that we've now got a period of time with many unknowns. What does that 1st of January look like when it comes to not just data protection, but all facets of the relationship with the EU? Now, if we look at some of the operational tasks for GDPR, I've tried to break these down into the main topics. And for context, the GDPR was 99 articles of kind of laws and guidance that was given to each country to implement. And it added an extra layer of complexity to many organizations where they had to run data protection impact assessments, for example, to iron out high risk processing activities. When we start looking at the consent obligation, the way that you gain consent from people that are signing up for your services had to be very much revisited and readjusted to make sure that it was legal with the GDPR. The 72-hour breach period is something that many companies are still struggling with. As soon as that company is aware, they've only got 72 hours to actually report that to their supervisory authority. In the UK, that would be the Information Commissioner's Office. And then there were rights that the data subject, the people that you're actually collecting information on, also were kind of adopted into the GDPR, into our national laws as well. That meant that you had to give them certain rights to be forgotten, to have their data deleted if they gave consent. All of these things were, on the face of it, very simple, but in implementation was actually incredibly difficult. And where this becomes an impact when it comes to Brexit, certainly, is that we might need to look at some of the liabilities that we have with our vendors and sub-processors. Which countries and what standards of data protection do we have in contract that we might need to review? When we have a record of processing activities, which is essentially as it says, a register that identifies all of the different activities by which you process data. So whether that is your HR system for your hiring program, for example, whether that's your CRM that is hosting all of your sales activities, each of these should be categorized and in a format that has been pre-agreed in Article 30 of the GDPR. You might need to relook at those. Now, the one that I think is probably the most impactful here when it comes to Brexit is the international data transfer. So I want to drill into a bit more detail on kind of data protection and that impact. Now, when we start looking at the data protection and the impacts, as I mentioned, from the 1st of January, the UK will lose quite an important status that it has right now, and that is what's called the adequacy of the UK to host and protect personal data. Now, if I'm a member state within the European Union, then I automatically get granted this right, I can actually say, well, we've adopted the GDPR, we have high standards of data protection for people that are concerned, the data subjects, for example. And, because we lose this status, we've actually got to make a case for adequacy later on. So, to keep that free flow of information after Brexit, we need to have a mechanism that essentially legitimizes that data transfer. And that is essentially the European Commission giving their kind of stamp of approval that that the UK is an adequate place that you can do business and you can store data to the same standard as if you were in Germany or France, someone that was actually in the European Union. Now, the thing that has been kind of counter in a lot of the discussions when it comes to data protection is actually our surveillance laws in the UK. This holds us back in some regards to how we conduct ourselves when it comes to data protection. Because you have to give rights to the data subject, often this is contrary to the security services and what their agenda with the access of data so that they can detect criminal instances and terrorism before it occurs. And this really does kind of play counter to the spirit of the GDPR, where you have to be very transparent about what you're doing with consumer data. So this has really been a part of the challenge when it comes to actually negotiating the UK out of the European Union, is this particular fact. Now, the UK actually took an interesting stance earlier in the year to, well, actually beyond that, but to adopt the GDPR into international law and essentially carbon copy into what's called the Data Protection Act 2018. So if you look at the Data Protection Act 2018, it is literally a copy paste of the GDPR, removing the aspects really around the latter part of it, which talk about cooperation with the other supervisory authorities. So this was kind of a step towards, well, if we have to kind of legitimize the data transfer to the UK from the EU, then it would be a good position if we start by copying the GDPR, because that is a good standard. Now, the aspect of this that is further complicated is earlier in the year, the UK government actually proposed a stance that was going to actually change some of the text around that data, and this is an opportunity, I think, for the government to kind of differentiate the UK from doing business in the EU. If it's slightly easier for companies to actually be able to set up in the UK, that is part of the discussion now. Is, well, how much do we want to adopt to the GDPR standard, and do we actually want to attract business, because we could actually lessen the degree by which the regulation holds, because in a lot of realms within the business, it's GDPR is actually a very hostile thing to actually implement, and it's seen in some areas as being very anti-profit and also too pro people's privacy, which is ironic. It's something that you would expect, but it also is counter to a lot of innovation, as it's seen. So ultimately what this means is that we're kind of in this balancing act right now, where at the heart of the Brexit discussion, the EU does not want to make this necessarily an easy process for the UK, let alone in the area of data protection. It may be to set an example from similar uprisings that might occur in France and Germany that might produce like a Frexit or a Drexit, however we want to term that. But essentially, you can see some of this posturing is really kind of political through these negotiations. After all, the data is the new oil. And, if we can be in a stronger position than we were, then it means that we can attract more business and ultimately be more prosperous. And this is really at the heart of the two sides of the coin in this instance. And the UK really is at a crossroads on the verge of Brexit. We have to decide where do we stand in relation to privacy? Will it be kind of a looser data protection regulation, or moving more towards like a China model, which, you know, we would guarantee our citizens' rights to privacy, but maybe moved more towards a Californian approach in securing a data adequacy just for the EU. So, you know, it's very, very much a topic of conversation that is, it changes day to day, because there are so many kind of emotions that are involved with this particular negotiation. And I think it's, you know, there's a very interesting article that is kind of, I kind of look at this as the worst case scenario for a lot of European companies, and certainly European data subjects. You know, there are suggestions that post-Brexit will become kind of a data laundering country, and essentially will be some kind of lawless dystopian, you know, country. It's really quite an interesting article. If you have time after this session to look at it, there's some interesting cases. You know, there's talk of us going from a country that was directly subject to the GDPR, as we are right now, to kind of a Chinese totalitarian regime here. And it's you know, it's a very huge leap, but it's a very interesting look into kind of what is the sum of all fears from a data protection standpoint as we go forwards. And the thing that makes this quite interesting is that, and this is not just data protection, but with a lot of other laws and frameworks that are subject to, you know, a joint connection with the EU. A lot of the time, the UK entity has actually been the louder voice in actually implementing these regulations and laws. And the GDPR is very similar. The Information Commissioner's Office sat on the European Data Protection Board and was, you know, a significant power in the actual writing of the GDPR. And so, you know, to go from, you know, a country that is subject to GDPR to, you know, something else, it's a very long stretch, and it's something that is quite interesting around the fears about, you know, what the UK will become in the eyes of the EU. Now, bearing in mind that the GDPR, although it's in force, it's been around for some time, I believe all of the countries have now adopted into local law, although it did take some time. There were several countries that did not actually go live on May 2018, you know, when it went live for the UK. But certain countries are actually still a bit problematic when implementing themselves the GDPR. So Hungary, during COVID, they actually removed this obligation around data subject rights because it was very difficult for businesses to support, which, you know, in theory is actually breaking international law. They're in breach of the GDPR in this instance. So it's not a perfect regime that even members of the EU are 100% behind, but it's important to understand, you know, this is kind of the sum of all fears from the EU and what they're trying to kind of enforce against. So, you know, moving forwards, you know, what are the options around data transfer, and where do we go from here, from a no deal or a deal type situation? Now, when we look at you know, the way that we legitimize the data transfer, so let's say you know, I'm a UK company and I'm doing business in the EU, and in order to do that, I require EU citizens' data. There's a couple of ways that I can legitimize that transfer, and this is kind of where we sit. So the first one seems logical. So we become a member of the European Union. Now, obviously, that's something that, you know, we've been pressing against, and obviously the reason that we're in the situation right now is that's no longer the case. The next one is to get an adequacy decision. And, you know, there are many other countries outside of the European Union that have actually applied through a very lengthy process to essentially apply to become an adequate country. And that basically means is that built into law, these countries like Switzerland, Japan, Israel, Canada, there's several others on here as well. They have basically said that when there is any data transfer from the EU to their country, that they're going to hold a standard that exceeds their kind of national law in the case of European data subjects. So it might be that they actually kind of carbon copy the GDPR or aspects of it, and then they get a tick next to the name again from the European Commission that would actually sign this off. Now, the other option is that rather than relying on your government, you can actually create a standard contractual clause. So whenever you sign up as a data subject in the EU and the data is going to another country, then essentially there are some EU approved kind of carbon copy templates that you can use that have the standards that are met by your company and that you are contractually obligating to. Now, the impact here is clearly there's going to be some administration that has to go with this to actually set this up. Every single process, every single technology vendor that you use as part of your day-to-day business will have to have some kind of update, especially when you've been leveraging the fact that we were in we had a membership with the European Union before, and we by default gained the adequacy status. From here, updating your contracts is probably the next logical thing. The next part of this is actually that you can leverage consent from the subject. So let's say a member in Germany, for example, wants to sign up for our services, and we don't have either a standard contractual clause or we don't have adequacy, or we're not a member of the EU. In this instance, you can actually ask for permission from that data subject and actually be transparent and say, hey, we're a UK company, we're not part of the GDPR. As of the 1st of January, we hold a high standard. This is kind of what it looks like to do business with us. This is how we protect your data. But we need your consent to actually sign you up. And this might be very easy for you to implement, or it might be very difficult depending on the process. But essentially, you can leverage consent in this example. Now, the other option is that we could use a government level bilateral agreement. So if you're familiar with the EU-US Privacy Shield, this could be another option where we actually have a bilateral agreement from the EU to the UK. But again, that kind of is something that needs to be signed off by the European Commission. And essentially, I think the best solution for the UK would to get adequacy. The problem is that this is a key part of the negotiation with Brexit right now. So if we do leave with a deal, I suspect that we'll either get some kind of fast track for adequacy, which means we don't necessarily need to do anything. But it's highly likely that there's, with the time remaining and the length of time that it actually takes to go through an adequacy process, it might be that we have to default to a standard contractual clause as a method to actually transact the business from the EU to the UK. So this is probably quite a good table to kind of highlight, what do we need to do and when. And I won't talk through each of these, but essentially, if I'm transferring from the UK to another third country, there's no necessary safeguards required because we would accept the EU's adequacy assessment. Very much kind of going from the UK to the EU, there's no additional safeguards. So I think the UK has been playing very, very well here. We're not making it difficult for EU businesses to do business with the UK. It's very much the opposite way around that we have issues, and this could all change depending on some of those standardized mechanisms as we go forwards. So I've put together a couple of bits of guidance around what's the Information Commissioner's Office said about this. And one of the things that I'll say about the guidance, if you reference the ICO and you've got a problem around how you're processing data and you need guidance, the ICO does a very good job of kind of helping you out here. And the way that that you can use this is that if you're implementing exactly how the ICO would like you to implement, it's going to keep you under the radar from any kinds of enforcement action against the Data Protection Act 2018 or indeed the GDPR. But it's a good way of trading off the uncertainty as to leverage what the government is saying. Now, the guidance that they give, through this transition period is that, if you're compliant with the GDPR, then you're more than likely compliant with the Data Protection Act. So it puts you in a good position if you're able to have a good standard when it comes to GDPR. Although it's the EU GDPR, if you've got your record of processing, if you have data subject rights, if you give good transparency on the notices and sign up forms that you have, then it means that you're already in a very strong position when it comes to any issues that might crop up. Mapping out your processes, I think many companies have gone through this already, which was called Article 30. But essentially, it just makes you look at each activity by which you process data and essentially document them. So if you're ever audited by the Information Commissioner's Office, you'd be able to tell them, this is where it sits, this is the information that we have, the categories of data, this is how we securely store this information and make sure that it isn't subject to any kind of data breaches, etc. It's very high level, but again, it's quite burdensome, to set this up if you haven't got this already. But having this mapped out will greatly help you. Adopt the standard contractual clause, as I discussed. You might need to look at these templates that you can actually download from either the Information Commissioner's Office or indeed the European Commission's website. They've got some standard contractual clauses that you can adopt into your contracts that you have, but it might be an instance where you need to review your existing contracts. So anywhere that you reference that you don't transfer any data outside of the EU, if you are storing that in the UK, that might be something that you need to revisit as we go forwards, because the UK will be treated as if it's a third country, and also you'd need to legitimize that using the standard contractual clause, saying that you as a company would hold high standards when it comes to data protection law. And the last thing to do really is to kind of look at your privacy policy. This is often where a consumer or a data subject will kind of see what is your appetite for keeping them safe. What are you saying about what your agenda is with the data that you hold? And the reason this is important is because transparency is very much at the fundamental pinpoint of the GDPR. Assuming you tell the people that you have data what it is that you're doing with their data, it greatly improves your position, not only from a reputation standpoint, but also from kind of future relations. How the vibe that you give to your customers, if you give them more than they asked for when it comes to what you're doing with their data, it gives you a good appearance to customers that are, if not now, concerned about their privacy later on. So it's something that's that you can also leverage there to kind of differentiate against competitors in the market as well. Now, the second piece that, and not to the same degree, but certainly something that is equally disruptive right now, is the notion of the EU-US Privacy Shield Agreement. And essentially, anyone that has been kind of in the tech space for the last sort of 10 years or so may remember there was a program called Safe Harbor. And this was actually Privacy Shield version 1. And essentially, there was a very famous case with a man called Shreems. It's also, you might hear it's in the news as the Shreem Agreement, or Shreem 1 and Shreem 2. But essentially, it was proving to the European Commission that the US was not a country that we could assume that had adequacy in the eyes of the data protection law at that time. And what this means is that basically they proved that the Patriot Act in the US kind of overstepped the bounds of the European data subject. So if you sent your data as a European citizen to the US, there was no guarantee that it would not be accessed by the American security services. So this was really where it got invalidated. And then a couple of months later, Privacy Shield was adopted that was designed to kind of fill some of the gaps that Safe Harbor had. Now, the interesting news from just a couple of weeks ago, in July, Privacy Shield has been invalidated with immediate effect. So really, we're kind of back to square one. And in theory, right now, anyone that's transferring data from the EU to the US that's leveraging Privacy Shield is, strictly speaking, not compliant with the law. But you can see these kind of changes. They're very disruptive to the business. But equally, they're not fastly enforced by the data protection authorities. So it's very interesting that the way that the European Commission is kind of stepping in on some of these aspects. So the things to note really around some of the Privacy Shield aspects is, there's inconsistencies between the different countries within Europe about whether standard contractual clauses are valid. Some have said that they're acceptable, some of them said that they're not. So it's not very consistent, which is one of the issues that a lot of companies are having. The costs to use alternatives, it does affect a lot of businesses when they're trying to be compliant with the law. They're trying to close any gaps with any of these issues. It is incredibly expensive to implement, not only from an investment time, from an employee standpoint, but there is an argument about whether or not Privacy Shield has any value in the future if every couple of years it gets invalidated by some kind of ruling by the European Court of Justice. So data protection resources, the authorities also have to vet. At the moment, there's 5,500 businesses that use Privacy Shield to legitimize their transfer to the US. The supervisory authorities or the data protection authorities, they have to vet every single one of these, and all of the organizations that rely on them. So it's very difficult for them to keep up with their finite resources as well. From the perspective of public interest, I think the European Commission would argue that they're acting in the interest of the European data subject. But there are circles that seem to think that this is actually a way to promote some kind of employment stimulus within the EU, so that people are forced to actually look at data subjects within the EU rather than leveraging the US or, in the case of Brexit, the UK. Sometimes it can be seen as kind of a pseudo stimulus package for the European Union. So, there's all of these facts that are kind of playing into this. And, some of the options, is it seems like a viable option for a lot of businesses right now to just do nothing. The one thing that's perfectly clear is that people cannot just simply immediately stop flow to the US of data for processes that are pre-existing, even when they use terminology like with immediate effect. Adding the standard contractual clause, it's a good option to use this, although it might be more burdensome in the first instance. At least you're not leveraging a framework that may be disavowed at any time, and it might even meet a UK-US transfer as well as an EU-US transfer as well. One of the options that you can look at, because Privacy Shield is based on fears around the national securities of the US, for example, is when you design systems and you work with vendors, if you design your solution or your process around the fact that you can't actually do anything with the data that you store and send to the US, if you can't read it, then it's highly likely security services can't read it. So having some kind of security or encryption by design can actually help with the implementation of anything that you need to set up when it comes to Privacy Shield. Having a strong privacy program, I mentioned this before, but if you can legitimize to your data subjects and to the security services that might have an edge here, that you are kind of putting their privacy first, then, you know, leading with your reputation, you have an opportunity to kind of legitimize that yourself through reason, whether that's through your privacy policy or when you sign up and you gain consent, for example. The other thing to look at is that, you know, Privacy Shield may return. It's highly likely that, you know, there'll be another kind of negotiation going on between the US and the EU, because ultimately it makes a lot of sense for the digital economies to work together. I think the one thing that's kind of very noticeable when we start talking about these cross-border data transfers is that, you know, the way that we implement frameworks and policy is very much, it doesn't take into consider the digital economy. You know, the ease at which you can transfer data is not the same kind of issue that we would face if we were sending a package to another country that's subject to you know, imports, etc. The digital economy doesn't care which country and who it is. By default, it's really kind of this overlay of information that that is giving this kind of issue context. So I think there are still some challenges whenever lawmakers kind of try and make laws around technology. They're always slightly behind the times in terms of, you know, what this means and the ease at which you can implement something in the world we live in, where cloud computing is now more popular than on-premise computing, as an example. So that kind of comes to, you know, the end of some of my topics. One of the things that I wanted to highlight was the way that the Artflux is architected. Is that we actually give customers the choice, you know, where do you want your information to be hosted? And this allows you to either use your own private cloud where you're hosting the information, or whether you're using a public cloud where you can actually leverage something in the UK or in the US or in the EU, depending on what your appetite is. So, you know, data residency laws do change. You might actually get different kind of agendas from the top level of the business, and being able to actually change this very easily is something that we've actually built into the platform. You know, the ability to lift and shift your data as you see fit. It's something that we tried to design from the ground up so that it's not a problem that customers will face in the future. And I think this is something that, you know, if you are looking for new software vendors, if you are looking at new service providers that can help you with a particular aspect of your business, I think it's an important thing to ask is, you know, do you have this capability? Will you use a standard contractual clause that have these standards that we want to meet when we're signing a contract with you? I think all of these factors are now going to be more important, that we've not necessarily got an adequacy decision or anything that we can leverage from government that would legitimize the data transfer. So I'm very conscious that I've been speaking for some time, and you know, I haven't been monitoring any questions. But if you do have any questions, then feel free to throw them at me. And Ollie, if there's anything in the chat that I've missed, then feel free to also follow suit. I will caveat that you know, I'm not a supplement for legal advice. I can certainly give you some insights as to how other companies have gone about it, but very happy to kind of entertain any questions or anything that you might have.
Thanks for that, Dave. Yeah, one of the things that's really worth pointing out, and we've spoken about this at length, is to really ask the question of the vendor that you're dealing with as to where your data is stored. That's the first thing. We've noticed that various organizations do move data between regions, and they do it without the consent, because they're really just rely on you as the data controller to get the consent as to where that data resides. One of the things that we set about at the very beginning was designing something that basically meant that you could host EU data inside the EU, UK data inside the UK, US data inside the US. And so straight away you weren't subject to any of those sort of data transfer rules and regulations. I think part of the challenge is that most people don't know today where their data resides. as businesses, they've not really got a good grip as to, you know, I've signed up for some cloud service. What does that mean to my data? Most software vendors though do have a page on their website that talks about where their data exists. So I think that would be a really good first place and first action, is to get, you know, that information together in order to be able to understand, you know, what the impact is to you from a privacy perspective.
Yeah,
There's
absolutely. I think the data processing agreement is basically where you would dictate, okay, these are, let's say we're using 3 or 4 different vendors to provide you this service. You would list out like, who are those different vendors, what service is it that they provide, and maybe even what data you send them. So classic example, a lot of companies will use an email provider, for example, to send outbound emails from a CRM, for example. So it might be, you have a CRM, you have your outbound email provider, you might have a backup solution that is in a separate location. You might have some other technologies that are linking in with that, that does ticketing systems, for example. All of these systems will be from different vendors, and they might be hosted in different locations and have different contractual clauses in place that kind of legitimizes that data. So you're right. I think the data processing agreement is where you're being very transparent about what you're doing. You're telling, you know, whoever's signing up, this is who we use, this is what we do, this is where it's hosted, and you can make that a caveat to whether or not they want to sign up, you know, at all with you as a company. And it's a really good option to kind of have, if you've got that mapped out, perfect. You literally can copy that into your data processing agreement, and then from there you've got a really good basis by which you can then gauge, is there any problems with the way that we've got this set up. So this email provider that we are using, that uses I don't know, Egypt as the area to send that information, that personal information. You know, maybe there's people that have objected in the past. So then that would dictate, okay, well, do I need to change my email provider to someone that is in the UK or in the EU? And it's a good way to kind of gauge that transparency. You know, which solution should I be choosing? Which one should I be going for?
And in terms of, you know, simplifying that journey, if you're locally sourcing solutions that are hosted inside the UK, you're pretty much there from a data perspective. It's only when you start dealing with people outside of the UK that you've got to start thinking about your processing agreements again. But it's not something that the government's been overly vocal about either, is it? In terms of, you know, grown at home, used at home resolves a lot of the problems. But also, going back to your point at the very beginning, data is becoming the new oil. And off the back of that, anybody that's seen any, you know, take a look at, has anyone seen The Social Dilemma? Anybody seen this on Netflix, just as a show of hands? No? Okay. It's worth looking at purely and simply because they talk about exactly this point about how you can influence decisions and all sorts. And if you believe the media, you know, things like elections can be transformed based on, you know, people's preferences and basically your personal data. So the outcome of that is that it's a very, you know, it's important to have legislation in place so that there's not the exploitation of that data, but ultimately not wrap everybody in that red tape that means that they can no longer do business. So there's got to always be that trade. But going back to your original point, the whole idea is the fact that the UK could become the Switzerland of data, right? If we have a bilateral agreement with the US and one with the EU, and the EU doesn't have a privacy style arrangement back with the US, all of a sudden that means that we're the only, you know, we're the midpoint between those two regions, right?
Yeah, absolutely. I mean, like with any change, there's always an opportunity, and I think it is a bit balancing act right now, because, you know, we are through these negotiations, and we don't want to get, or the EU is very careful not to give us too much of an easy time. That will mean that businesses will kind of shift to the UK from, you know, their counterparts in Europe. You know, ultimately the European Commission is on the side of the European citizen. So any decision it makes is ultimately to benefit, you know, the European citizen over, you know, a UK citizen. but I think this is both the opportunity, but it's also the danger. I think if we went for a trade deal, we could easily come out much worse than than if we didn't. So this is part of the discussion points that have been going on, and back to the point around the Information Commissioner's Office having such a vocal kind of standpoint when it was developing the GDPR. It's slightly unusual to think that the EU would say that the UK is not adequate, because it wrote the GDPR. It's had a lot of influence when it came to writing that regulation. So to call the UK not adequate is almost to say that the GDPR is not adequate. So I think, like with anything, it looks very petty when you look at this from the 30,000 foot perspective, but it's very interesting to kind of see how this will play out. But yeah, I think there's still a lot to be worked out by government before businesses can be rest assured that things are going to be okay moving forwards.
And again, when you think of the build up to GDPR in 2018, there was this kind of massive PR exercise going on by a lot of businesses around, are you ready? Are you ready? And then all of a sudden, post May, it was like disappeared as though it was no longer there and no longer needed, but it's always bubbled away beneath the surface. Going back to what you were saying, what was quite interesting as well is the fact that when you look at Privacy Shield, 5,500 company audits plus all their suppliers, all of a sudden this sprawls out and becomes a massive technical exercise. And not only is it an exercise for the organization to get all of its data processing agreements in place, but it's also an exercise for that to be policed. If we look at BA is probably the biggest case of this, certainly that I'm aware of. We sat there and watched that like a hawk internally, purely and simply because their security practices. For anybody that doesn't know, ArcFlux is a marketing and CRM platform that covers social media, email, and everything else, which is why this is such a big deal to us. We watched how BA dealt with their hack and those processes and the breach of data. And the output of that is they were fined pretty heavily, right, Dave? What was the process of that in the end?
So yeah, BA, the way that it works when we're in the EU, when there's a breach like this in an investigation, there is a single supervisory authority that takes the lead on auditing and seeing if the law was broken. In the case of BA, it was the ICO that was obviously elected by the member states to kind of investigate and prioritize. And they ultimately found that it was the most serious breach of the GDPR, which you've probably heard the numbers. It's 4% or 2% of global revenue, and or either 20 million euros as a fine or 10 million euros as a fine. And they found that BA was kind of the top end of that. So it was around about, I think, 300 million pounds was the fine that was kind of handed down. Now, very recently, the ICOs actually settled with BA for a fine around about 20 million, which is obviously a vastly lower number than the GDPR would dictate. And I think that's made some of the supervisory authorities in Europe very nervous, because again, if you can open up your business in the UK and misuse data either accidentally or purposefully, then you might get a better deal when it comes to enforcement, because the ICO is not going to enforce you as heavily as, let's say, the Garante in Italy or the CNIL in France, for example. So this has kind of opened up a can of worms, although it's quite a hefty fine. I mean, especially with airlines right now, they're having a hard time anyway. I don't know if that factored into the decision from the Information Commissioner's Office, but certainly, that's made certain supervisory authorities and the European Commission a bit nervous, because if the UK is seen as a bit of a soft touch when it comes to enforcement, that's enough for a lot of businesses to decide to actually move to the UK because they could potentially save, in the case of BA, £270 million per infraction.
Yeah, but yeah, it's definitely an interesting process. I think the net of it is that um, as long as your best practices are in place and you're not doing anything nefarious with data, then you're not going to stand out to the ICO. What the challenge is that as soon as you fall over and trip over one thing, then the book's going to come at you. And that's really what we saw in the BA case. You and I both know from years ago there were other airlines that were in breach of credit card data and all sorts of things. And they technically got away with it scot-free based on the fact that GDPR wasn't around and it wasn't enforceable. Has anybody else, got any questions with regards to GDPR and privacy? I'm going to go with the standard Zoom 5-second rule in order to be able to get off unmute and start talking. I think, John, you know this more than anybody else. I'm scared to ask how many conversations you've had around imports and exports associated to Brexit, and that's in physical goods, let alone data, which is an entirely different conversation. I don't think it looks like we're going to get all of those answers before the end of the year on either count, really. What have you heard anything at sort of a government level around privacy and security, or is it just, keep going with GDPR?
I think most people are more concerned with the supply chain at the moment, and that's where their focus is. I don't think they're really thinking about the data transfer because their main thing is how do we get continuity of business? How do we make sure that we can serve our customers, we can get our goods into this country without any challenges and blemishes in the supply chain. So to a certain extent, I think that the data side is one that is well down their list of priorities. If you're right, and we look at it, I mean the government says that in terms of the kind of question that it's been doing, 75% of businesses are not even preparing for the actual transfer of goods between ourselves and the EU, let alone looking at the data side. And certainly we know now that people are beginning to really focus and understand the challenges that they may be facing. And there's a lot more traction with businesses, and we're running a lot more events and courses to help people to understand the actions that they take now. And we've just launched this afternoon about, prepare now for a no-deal Brexit. Make sure that you've got everything in place. It's no good waiting till the last minute. And if you prepare for that, then you'll make sure that you can cover all the eventualities that we might end up with, whether it's an Australian type deal or a no deal at all. And it's real key for us to be able to communicate with businesses now to explain what they need to do, how they need to do it, and to give them the toolkit to be able to prepare themselves for the inevitable significant changes that are going to happen on the 1st of January through any of the kind of scenarios that we may end up with the governments and the EU chatting. Who knows? It's pretty political rather than practical, and that's the real concern. And strangely, businesses are much more concerned about the challenges of the change in our relationship with the EU and how we continue to trade with them. And even talking with colleagues in Liverpool today who are actually gone into tier 3 and obviously got great disruption, they're saying actually we still believe that the end of the year and the Brexit situation is actually more of a challenge to us than what we're actually facing now. So it begin to see the regard that businesses have and how this is fast becoming absolutely the top of the priority list, because it's happening very quickly, and we'll soon be there. And we can't afford to blink. We need to make sure that we've got all the mechanisms in place to protect our business and ensure that we can have complete control over what happens. It's really difficult because for some businesses there are outstanding questions, despite the government saying, you've got to get prepared. And one of the messages we're saying is, please do not start to challenge business about not being prepared, when actually there are key questions that we keep asking you, which you cannot give us the answers to, which many businesses need the answers in order to prepare in the way that you're suggesting they should. So I think this will go on, but nevertheless, there are lots of fundamental things that people can do to get themselves ready for the start of the new year. And I have to say, one of the reasons we wanted to talk about the GDPR and the data today is it's a topic that people are not necessarily thinking of or understanding what, if anything, they need to do to be able to continue to transfer data in both directions in the way that they need to under new legislation.
I think as well, the problem is with the data side is it's as simple as a single click. And that's an entirely different model to when, if you take the construction industry and the goods that they buy from the European Union versus a single click inside a web browser, right? They're entirely different models. But it was interesting as well because the physical goods side of things, will impact pretty much every business. It's not, well, I don't do imports and exports, so it's not going to affect me. It's that whole supply chain, right, John? And so that's the bit that's going to be impacted.
Yeah, but it is really, and that's where people are focused. And Sadie, who's on with us, we launched our event on the 9th of November, just this afternoon, to look at that you've got to prepare for a no-deal Brexit. And within an hour, we have got 45 businesses booked on it, which shows the increasing rapidity in which people are seeing this as a key issue going forward, and the fact they need now to get their minds around what they need to do and how they need to prepare to ensure that they can protect themselves as much as possible.
Do you think it's worth to... Oh, sorry.
We're up to 80 on that event now, so it is going to be a popular event with what people need to know and what they need to do.
Yeah, I think it does, and that absolutely shows, and why we want to and will continue to have key events with the people who have the specialist knowledge to be able to help and get people to understand the steps they can take now to prepare themselves for all the changes that are coming our way.
Hey Dave, could you just rewind the deck back to that kind of, if from here to here based on the scenarios, just so that anybody that, yeah, that's it, perfect. I mean, obviously this is not a legal document supplied by Dave because he's not a lawyer, but it's certainly a great first step in terms of understanding how those international transfers happen. If anybody wants to screen grab that now, that just as a takeaway, perhaps as well, John, if it's of interest, we could host a follow-up session a bit closer to the deadline, because we'll know then a bit more as to what the impact would be, whether there'll be sort of any bilateral agreements or etc. in place.
Yeah, that'd be great. And I think, as we go on this journey, which is a journey we're all going to go on together, with lots of information and things changing, then we need your expertise to be able to help and communicate with us and everybody else what that now means for their business and what actions they need to take.
Yeah, and with that, the local business champions have been a fantastic series, and there's been an awful lot of fantastic data. We're, like I said from the outset, we're a software platform that specializes in digital marketing and CRM and automation and business automation and AI. The outcome of that is that Dave's our in-house GDPR and privacy expert. So it's not necessarily what your business does in terms of output to customers, but actually some of the mind share in your teams that can help other people, right? It's about exposing information that people need to understand to make this a smoother transition. Unfortunately, the UK didn't come out and say that we need to just forget about GDPR as a result of COVID, Dave. So it looks like we're all in this boat together. So if there are any other questions, happy to field those now. Otherwise, there will be a recording There is one question here from John, actually. I may have missed it, but you said whether there is somewhere I can find a list of all the countries with an adequate assessment, adequacy assessments. That's the ICO, right? I think.
Yeah, the European Commission website also lists it as they're the ones that actually specify who is adequate or not. But yeah, there's a number on there, but I can follow up with a link if that's easier.
If you could let us have that, we'll send it round to everybody, Dave.
Okay, wonderful. I'll send that on.
Yeah,
that'd be great.
Ping it to me, and then when I send the recording to Sadie, I'll make sure.
Oh yeah, yeah. If you add that on, and then Sadie will send it round, that'll be great.
That's awesome. Well, with that, it's the hour up as usual, John, and everybody's still on the call bar 1 or 2 people, so that's normally a good sign. Everyone's camera's predominantly off though, so we can't check whether they're still at their desks working and listening. But we'll go with the fact that they are. Next in the series, what's apart from the event you were talking about a bit earlier, is there anything else people need to know that's coming up, John?
Yeah, I think that we run these events every second and fourth Thursday, and of course there's 5 Thursdays in October. So next week we're not actually running anything, as it happens to be half term as well. But we resume on the 5th of October, if my memory is correct, and we've got the actual chair of the British Chambers of Commerce, Sarah Howard, who is a local business person who's actually joining to talk about leadership through her journey, and you know, the way that she can help to develop all that's ongoing, and particularly about, you know, the having ladies within leadership roles and the kind of challenges that she's faced. But she's really very good, and it will be an excellent session for our leadership forum with Sarah Howard, and we'll be obviously and are sending out all the details regarding that, and look forward to seeing everybody there. And it's one not to miss, because I think you'll find it quite stimulating and motivating listening to her, and most people that do take some really good things away from the events that she's involved in.
Awesome. Well, thank you for that, and as always, have a good rest of your day and a good week. Thank you very much for joining. Thank you very much, Dave, for putting together this presentation. You were a very valuable member of our team to keep us on the straight and narrow from a privacy perspective, and I respect your time today and the effort that you've put into to produce this. So thank you very much. And thank you, John and Sadie, for organising as always.
Yes, and thank you from us, Dave and Ollie, for taking the strain as always. All much appreciated. And we look forward to continuing this series with all the information that we need to ensure businesses are aware of and can use for their own protection for the future.
Lovely. Thank you, everyone.
Thank you. Thank you for your time. Bye-bye.
Thanks. Bye.
Bye.
Bye.